The last thing I want to discuss before we end this segment is financial planning as a source of or a remedy for people that are potentially facing foreclosure or can't make their mortgage payments or don't want to make their mortgage payments. Financial planning can have a significant role. So what I do when I do financial planning for a client, I'm looking to accomplish three things. First, in an absolute doomsday scenario where you had an aggressive creditor that did foreclose and pursue a deficiency judgment, if you have to tell a creditor, let's say in a deposition, they are asking about your assets, I want you to truthfully, because you have to be truthful in a deposition, to truthfully answer their questions, to tell them exactly what you have done, and to still make it very difficult, if not impossible, for a creditor to touch any of your assets. The other thing I want to accomplish is something called financial privacy. Now, financial privacy is a little bit different than true asset protection. True asset protection is not dependent upon secrecy to work. The reason I want financial privacy as well is because I find, from my experience in my practice, that many times before a lender makes a decision whether to pursue collection of a deficiency judgment or to write that debt off as a bad debt, they will, unbeknownst to you, do an asset search. And if their asset search shows that you have lots of money in the bank, or that you have property that's free and clear or has lots of equity in it, now they're going to lean more towards pursuing collection because they know they can collect. On the other hand, if they do an asset search and don't see anything, there's a better chance that they're not going to pursue you for collection because, again, from my experience, and I can only tell you about my experiences, a lender typically does not want to pay more money for attorney's fees and costs unless they know there's a pot of gold at the end of the rainbow, unless they know there's something to collect from. So if they do an asset search and don't see anything, well, you haven't lied, you haven't told them that you don't have anything, but if they assume you don't have anything because nothing showed up on an asset search, they're more likely to write this off as a bad debt and not pursue it in the first place. And really, that's the best type of asset protection, is to not get sued. And I want to try to give you the best chance of that happening for you. Lastly, for those people that want to do a short sale or a deed in lieu of foreclosure, I find that at that stage in the game, the lender is not asking very detailed information. So it's for that reason, if we know the information that the lender is going to ask, and I deal with banks all the time, so I've seen their financial forms, we can try to plan for that event. And if we can plan so that you can truthfully answer the bank's financial statement without disclosing all your assets, well, that gives you a better chance of getting your short sale or deed in lieu of foreclosure approved. And my opinion is you're under no legal obligation to volunteer information to the bank that they don't ask you. If they ask you that and you're answering it under oath, you have to answer it. If they don't ask you the question, you don't have to volunteer information they don't ask. Now, let's talk about one last thing. If we're able to accomplish this for you, the client, and the lender goes away and writes this off as a bad debt, and really, that's a good day for you because you know the lender's not going to be pursuing a deficiency judgment. There are still some potential tax consequences as a result of that. See, if the lender writes it off as a bad debt, let's go back to my example in the beginning where you owed $300,000 on a mortgage. At the time of a foreclosure or short sale or whatever, the lender, the property is now only worth $200,000, and let's assume we weren't able to get the lender to agree, or we were able to get the lender to agree to write this off as a bad debt. Well, now the lender has a $100,000 loss, and when they write it off, typically, but not all the time, but most of the time, they will send you what's called a 1099, and they will report their loss as income to you, and now you are responsible to pay the tax on that income. Now, fortunately, Congress, in their infinite wisdom, passed an act called the Mortgage Debt Relief Forgiveness Act. And that act is currently good through the year 2012, but before it was good through the year 2010, and they extended it till 2012. So hopefully they'll extend that again when 2012 comes up. but at the time of this taping, it's good through 2012. What this act says is that if you receive a 1099 from a lender due to a default on your mortgage, that if it was your primary residence, and by primary residence, it has to have been your primary residence for 2 of the last 5 years, then you are forgiven for that tax. Now, there is an IRS form called IRS Form 982, and you would check box E on that form, which says that discharge of qualified principal residence indebtedness, and you're now notifying the IRS that you are exempt from the taxes, and because you are exempt from the taxes, you don't really have any tax consequences. There's also a provision on that same form for insolvency. So if you can prove to the IRS that you're insolvent, you also are exempt from the taxes. But there are some of you who are solvent and who had, I guess, negotiated with the lender on investment properties, got the lender to agree to write it off. Just to let you know, there are potential tax consequences, and you should consult with me or ask me or your financial advisor or an accountant about ways that you can hopefully avoid these taxes or at least reduce them. The last thing to talk about when we talk about asset protection or financial planning, as I like to call it, is something called a fraudulent transfer. Now, there is something in the law called the Uniform Fraudulent Transfer Act. And the Uniform Fraudulent Transfer Act basically provides criteria for a court to consider as to whether something was done for the sole purpose of asset protection. Let me give you an example. If someone were to take the deed to their property that was free and clear, and they were worried that a creditor might, put a lien on that property and take it away from them, and they transferred that property to, let's say, a son or daughter, that would be a pretty easy fraudulent transfer argument if it happened at a time where you had an actual known creditor. Because one of the factors under the Uniform Fraudulent Transfer Act is the timing of the transaction. Another factor was the transaction to an insider, and another factor was there fair consideration for that transfer. Now, there's many other factors, but on these 3 main factors, it would fail and it would be considered a fraudulent transfer. You transferred it to an insider, a close family member or friend would be an insider, at a time where you had a creditor or a known a creditor that was looming, and there was no consideration for that transfer. So when you think about doing asset protection, it's important to go to someone experienced that knows how to avoid these traps, these fraudulent, and to do asset planning in a way that it would not be considered a fraudulent transfer. And the last thing I would like to say is time does matter when it comes to doing financial planning. You don't want to wait till the last minute because you don't want to give a creditor the opportunity to unravel this as being done for the sole purpose of asset protection. The earlier you can get to me, the better chance we have that this wouldn't be considered a fraudulent transfer under the Uniform Fraudulent Transfer Law. Now, I want to be clear. A fraudulent transfer sounds really bad because of the word fraudulent, but it is not criminal to do a fraudulent transfer. It doesn't add any additional liability. It just gives the creditor, or gives the judge actually, the power to undo whatever you've done and put it back the way it was before so your creditor can attach to it. So that's an important consideration, but you definitely want to do asset protection, because if you have a property that's free and clear, or you have large amounts of cash in the bank, that is something that is going to be easy for a creditor to get to, and it will make it more likely that they will pursue a deficiency. Even if you've done something that's maybe the timing wasn't ideal, at least you've made it more difficult for the creditor, which enables us to open up a dialogue to get things negotiated as a discount. But if you want to avoid a fraudulent transfer altogether, or an argument that a fraudulent transfer, come to me as soon as possible in the process, because time does matter.